What?
All right. Okay. So we are live on Facebook. I want to thank everyone for joining us tonight. We're going to get started here in just a few minutes. In the meantime, I'm going to drop a few links over here in the chat, including our accompanying documents for tonight's event, as well as our webpage and our links to our literature that are on our webpage. So give me just a few more minutes. So the first link that I'm dropping in are the accompanying documents for tonight. And then I'm going to drop another link that's our resource page and includes various documents, publications, including the documents for tonight. And I just want to let everyone know that we're also live on our Facebook. So you can stay here with us on Zoom. You can also go over to our Facebook and join us live at Delaware Cannabis Advocacy Network. And just give us a few more minutes. We'll get started right at 7. Thank you all for joining us tonight.
Does that copy your link?
No, it doesn't. Let's see if this will do it. That should do it. Okay, so there's the link. All right. So, thank you all who are just joining us on Facebook Live. We're going to get started in just a few minutes. I don't have the Facebook open right now, but while Attorney Adam Windett is speaking, I'm going to drop some more links in our Facebook Live event as well. So everybody gets the same links that we're dropping here in our chat. But welcome everyone, and thank you for joining us for Fight Back, How to Win Your Cannabis Possession Case featuring Adam Windett. We'll get started here in just a few minutes. Thank you all who's joining us on Facebook Live. Give it just one more minute and then we'll get started. Okay. So I'm also going to drop in the chat here real quick before we get started information on how to volunteer and how to get involved, how to contact us for information about the information that we give out tonight, as well as expungements and our legalization efforts. So that's over here in the chat now. Okay, so it's 7 o'clock, we're gonna get started. I just wanna thank everyone for joining us tonight for our event. Oops. Okay, there you go. Thanks for joining us for our event tonight, Fight Back, How to Win Your Cannabis Case. My name is Zoe Patchell, and I'm one of the co-founders and the executive director of Delaware Cannabis Advocacy Network. Delaware CAN is an all-volunteer, citizen-led grassroots advocacy group that's been lobbying since 2013 to repeal the criminal penalties for cannabis offenses, initiate criminal justice reforms for those adversely affected by cannabis prohibition, and legalize a safe cannabis market for adults 21 and older. Delaware CAN has organized or participated in over 350 events since inception, including citizen cannabis lobby days, town halls and public forums, advocacy trainings, local community events, expungement and pardon seminars and fundraising events, as well as Know Your Rights seminars and more. This particular event tonight is part of our Know Your Rights program series and will focus on what to do if you're charged with a misdemeanor cannabis possession offense or civil citation, and how to fight your case by taking it to trial and to be successful at trial. We're very, very excited and fortunate to have one of our co-founders of Delaware CAN here with us tonight, attorney Adam Windett, who will be going over a step-by-step process on how to successfully fight your cannabis possession misdemeanor or civil citation case. We're very thankful to have Adam Windett here to do this program tonight because according to data from the Delaware Statistical Analysis Center, there are approximately 6,000 individuals every year here in Delaware who will either be charged with a misdemeanor cannabis possession case or issued a civil citation for cannabis possession. These cases do not even include felony cannabis charges, just simple possession only cannabis offenses, and they occur on average 13 times a day, over 100 times a week, and over 400 times a month on average. Since decriminalization went into effect in 2015, there have been a slight decrease in misdemeanor possession arrests. However, there's been a 127% increase in possession-only cannabis cases, which now make up 52% of all the drug offenses here in Delaware, according to the Delaware Statistical Analysis Center. The human cost of cannabis prohibition is absolutely staggering, and these offenses have a lifelong impact on a person with over 700 collateral consequences from a criminal conviction, not to mention the emotional scars left by an arrest. Currently, 30% of the U.S. population now lives in one of the 15 legal states where people are no longer being prosecuted for these possession-only offenses, and soon to be our neighbors over in New Jersey. It's past time for these possession offenses and the police contact to end here in Delaware. Unfortunately, we don't have the luxury that other states like New Jersey had, where voters were able to end cannabis prohibitions at the polls by voting in favor of cannabis legalization. So unfortunately, we must rely on our legislators to introduce and pass a bill through the General Assembly, which reconvenes next week after their 6-month break. The good news is that Delaware is on the brink of legalization, and the third version of an adult use legalization bill is due out when session reconvenes this month. However, with having to go through the legislature, it will likely take a few months to pass this measure through both the House and the Senate. In the meantime, thousands of cannabis consumers will likely end up with a possession-only offense before that piece of legislation is signed into law this year. According to the Substance Abuse and Mental Health Service Administration, 18% of Delaware adults consume cannabis, leaving approximately 125,000 to 185,000 Delaware adults in jeopardy of becoming the next victim of the war on cannabis. This is why it's so important for us to do this event tonight and make sure that we're giving citizens the knowledge and the tools to be able to defend themselves if they're charged with a misdemeanor cannabis offense or issued a civil citation for cannabis without having to pay an attorney, which can be very costly, especially after having your cannabis seized during the arrest or even money or property seized during the offense. So again, we'd like to thank attorney Adam Windett for joining us tonight and putting together this much needed program. Adam has been practicing criminal defense for 13 years at his firm, Hopkins and Windett. In his career, he regularly litigates cannabis cases here in Delaware courts and has received favorable decisions in key cannabis cases, including case law that allows probationers to use their medical cannabis without their probation being violated. And that was in State versus Perry, as well as further medical cannabis patient protections, including in State versus Jernigan. And Adam spent a considerable amount of his time in the many roles that he does here at Delaware CAN and is also the founder of the Windett Education Fund. Please help me welcome attorney Adam Windett. I'm going to slide over.
Thank you, Zoe. And thank everyone for coming tonight. Let me get situated here. That's not mine. All right, let me get up my notes here. So first off, I hate to do this, but I have to do a lawyer thing, right from the start and give a little disclaimer. Essentially that is the information that's going to be in this presentation. It's provided for educational purposes. It's not intended to serve, as legal advice or create any attorney-client relationship between me and everybody on this call. each case is a little bit different. And as best practice, if you're charged with a cannabis violation, it's a good idea to at least speak to an attorney. Many criminal defense attorneys, I do free consultations, many others do. So it's advisable if you're charged in a case, talk to somebody before you take on this venture yourself. But ultimately, I know that it can be expensive to hire an attorney. So, I want to provide people, we want to provide people with, the tools to defend themselves if that's the case. And this seminar was developed, to be informational, but, it's also a call to action. With the system that's in place right now, decriminalization only works as the state intends it to work if the vast majority of people who are charged with civil violations and petty cannabis offenses don't fight back. Their system relies on people, taking the fine and just simply paying the fine and not fighting back. On the other hand, if we all work collectively and consumers charged with civil violations and possession offenses, make the process as costly and as onerous as possible for the state, we can disincentivize enforcement of possession only offenses. So if the state's going to continue to treat cannabis consumers like criminals, harass us, take our product, and then fine us and charge us court costs, rather than roll over and pay a small fine to avoid the inconvenience of going to court, we should be responding to the state in kind. If they're going to be a major pain in our ass as consumers, we should be a major pain in their ass, as our oppressors. So to start, let's talk about the current status of the law. Delaware has decriminalization, as you heard Zoe mention. The number of citations and arrests are up since decriminalization. Part of that is decriminalization doesn't cover all cannabis products. Only cannabis flower is decriminalized and only up to an ounce. So decriminalization doesn't mean legal. Violations are civil, not criminal. The process and outcomes are similar to low-level criminal offenses. They just don't appear on your criminal history. So if you're charged with a cannabis civil violation, you could still get pulled out of your car, put in handcuffs, put in the police car, taken to the station, fingerprinted, and go through the process. It looks just like the criminal process. Just in the end, when you get the fine, it doesn't appear on your criminal history. So the court process, very similar. One of the only differences is, the burden of proof in a civil violation, the state only has to prove it by a preponderance of evidence, whereas if it's a criminal offense, it's beyond a reasonable doubt. The state, in these cases, seizes your property. They take your cannabis from you. You don't get it back. So while it's not criminalized, you still lose your property. And if you have any cash on you, some people have their cash seized and have to fight to get it back. Now, if you're found responsible for a civil cannabis violation with the $100 fine and the court cost, it adds up to about $131. And that's pretty typical of low-level misdemeanors. Get a $100 fine. So it looks very much like a criminal case. And so let's talk about what's still criminal. Up to an ounce of flower is decriminalized. It means you're still going to get the civil violation in the fine. What's criminal? Anything over an ounce is a misdemeanor offense. Possession of anything other than flower, so edibles, tinctures, concentrates, anything other than flower is still a misdemeanor offense. And then if you possess enough, if you have over 175 grams, they'll charge you with aggravated possession, which is a felony, or drug dealing. And then all non-possession acts are still felonies. So cultivation, manufacturing cannabis products, sales, even just giving it away. If you have something, you give it to another person, even if you don't charge them, it's still technically under Delaware law, drug dealing. So that's most acts related to cannabis are still criminal, and the civil violation still looks very much criminal. It looks like it, just doesn't have that mark on your record. But the police don't always get it right, and there are people who are being charged with misdemeanors for things that's just a civil violation conduct. So why should you fight your cannabis possession case? And there's sometimes when perhaps you shouldn't. So we'll talk about those circumstances. And first, you could say there's the financial aspect. And what I said when I was coming up with the ideas for this, little seminar was, the police already took your weed, why let them take your money too? They've already taken something from you, and why just let them have that fine and, the court cost? Most people pay the fine because they don't think it's worth their time going to court or missing work. And I can tell you, to fight one of these cases, you're talking about only a few hours of time. So for many, a few hours of their time, $131 is quite worthwhile. And when you consider that cannabis civil violations fall under the jurisdiction of justice of the peace courts and aldermen's courts, which most of them, the JP courts, are 24-hour courts, often you can get a trial scheduled around your business hours. The last justice of the peace court trial that I had was at 8 o'clock on a Friday night. So my client didn't have to miss work, and it was to fight a petty violation just because it was wrong and she was right and she won, and she spent her time to fight something on principle. And that's the real reason, to fight these charges is on principle. The people of Delaware want legal cannabis. It's over 60% support. The majority of legislators want it. The only holdup is a lack of legislative action because of some procedural hurdles and other things that have happened in the past that are probably beyond the scope of this talk. But law enforcement and the legal system, they don't care about majority public opinion. They don't care about the fundamental unfairness of charging people and taking people's property and fining them when most of the state is against cannabis prohibition. They don't care about the economic waste of spending the money on, law enforcement to collect civil fines that are only a small fraction of those enforcement costs. The money that comes in on these fines is way less than it costs to enforce DCAN. So as long as cannabis is not fully legal, cops are going to keep harassing consumers, and they're going to keep charging people and embarrassing them and, putting them in cuffs and putting them in the car. The cops are going to keep doing that. The prosecutors are going to keep moving forward with their cases. The cops that charge people in JP court and justice peace court, the cops prosecute the case, not a prosecutor. So the cop is going to go forward with that case, and they're going to come to court most of the time, albeit most of the time not prepared. I mean, they're going to come in there, the machine's going to move forward on that. But if consumers stand up and fight and make the process, more and more costly and time consuming for law enforcement and the courts and the states, that's going to provide a real disincentive, for these continued prosecutions of these small level cases. And if cannabis consumers start winning these cases, and the state is investing time, and these cops are investing time, and they're having full blown trials on these petty, possession violation cases, and not winning and not getting any court costs and not getting any fines, maybe they'll see the error in their ways. And I mean, worst case scenario, the cops in the state refuse to give up on prohibition, and they keep fighting this thing. And then in response, we just bleed them dry as consumers and as advocates. We make the prosecutions as expensive as possible. We make them as time consuming as possible. Collectively, a few hours from each of us adding up to the state is a ton of time, taking cops off the road for thousands of hours, clogging the lower courts with these small possession cases, just having trial after trial. If you come in and pay the fine, it takes them no time. If you demand a trial, it takes about an hour, maybe a little bit more, but generally about an hour in one of these small cases. So for an hour of your time, you could take a cop off the road for an hour and a judge off another case for an hour and start showing them the errors of their ways, and then publicize these results. If you get a cannabis case and you beat it and you use these methods and the state screws up the way I'm going to tell you they usually screw up, let people know and let your legislators know what's happening in these cases, and that they're putting people through this process, and it's just a futile process. So there might be some circumstances where going to trial is not the best option. I'm talking when I say it's a no-lose proposition going to trial on a civil violation only. But I mean, if you're charged with anything other than a civil violation, like if you have additional criminal charges, there may be benefit in making a deal. That's something you really got to talk with an attorney or an expert with, or an attorney is your only expert. But so if you're charged with just a civil violation, nothing else, no other violations, which a lot of people do. I've represented a lot of people who get those charges, just a civil violation. If you pay and admit to it it costs you $131 and no mark on your record. If you go to trial and you're found responsible, you owe $131, and you teach a little lesson to the state that only costs you an hour of your time. So really, it's a no-lose proposition. And then if you go to trial and you win, you save $131 and you send that same lesson to the state. So it's really a no-lose proposition in these civil violation cases to just fight it and make the state earn it. And often, even in possession cases that are misdemeanors, sometimes those cases are worth it because they're mischarged or the state's made errors in those cases. But most of these comments I'm going to make today are about civil violations. Obviously, if you're charged with a civil violation and a felony gun charge, that's not what we're talking about today. Don't say, I'm going to fight this because it's a civil violation. It's got other charges with it. Those are the things you want to talk with an attorney about. If you have a cannabis violation plus something else, don't try to use these tactics on this. That might not be in your best interest. Talk to an attorney, try to get a free consult with somebody. What we're talking about today is about civil violations and some misdemeanor violations. And it's important because there's still thousands of those a year. The majority of them don't have any other charges associated with them. So in theory, this is something that could be used by advocates to spend thousands of hours of the state's time to show them that they're losing this fight. So there's a couple of tactics that can be used by everybody to fight your cannabis possession case and be successful. These cases, as I said, the civil violations are prosecuted in the Justice of Peace Court and Alderman's Court. And when you go to Justice of Peace Court, I'll call it JP Court. And I know I'll keep doing it because it's just a habit. When you go to JP Court, those cases are prosecuted by the officer that makes the arrest. A prosecutor doesn't get involved in the case. If it's a misdemeanor cannabis violation, that can be transferred to the Court of Common Pleas, where a prosecutor will then be involved in the process. But I want to start with talking about the civil violations, the one where we can really send a message, and the one where we're talking a few hours of your time at the most for $131 with clear paths to victory, because there's some secrets in these cases that they're not telling you as they continue to enforce these laws. And I'll just get to it right from the start. The secret is they're charging people with cannabis violations, civil violations, and they're not testing the product. So part of the proof that's required to prove these things, they have to prove that the substance was cannabis, and they have to prove that the person that they allege to have possessed that substance. And the state is simply, and these police agencies are relying on people to just pay the fine. They're not testing the product. Often they don't have the evidence to come to court. There's ways to find out if they have the evidence and they're ready to come to court, so you can assess your risk going into it. But I can tell you from experience, the way to win most of the time is to take advantage of your ability to discover information that the state has in their possession before the trial, and then using that information to block the state's testimony. And essentially, they can't show that what they seized was cannabis, and therefore you win your case. That's the main number one secret to how to fight these cases. Now let's talk about how to do it. So when you get charged with a civil violation, you'll get a citation, you'll get a court date to appear at the Justice of the Peace Court. When you go to your initial appearance in the Justice of the Peace Court, it's for an arraignment, and they're going to ask you, how you plead within 10 days of doing that, or you can do that in writing. Within 10 days of doing that, you have the ability of filing for discovery and inspection. And what that means is you can file a written document and asking for the state to provide evidence that they have in their possession that they're going to use against you. And when these cases are in JP court, that's a request that you make of a police officer who's not legally trained. And in my experience, they're not very good at these things. So they have an obligation to turn over to you, any photographs, any documents that they're going to use, any results of scientific tests or experiments is the big one. Any statements written or recorded by you or by a co-defendant, and anything they intend to use against you in the case. They don't have to provide you police reports, but often they do. So within 10 days of being charged and having your arraignment in a civil violation case, you can send a written request and ask for all the evidence that the state has, essentially, that they plan to use against you. And the reason why that's important is if the state sent what they say sees from you, which is likely cannabis, if they send it to a lab to have it tested, they have to turn that testing over to you. And that's the evidence that they have to present at a trial to prove that a product was cannabis, is they do a gas chromatograph mass spectrometer test that determines what the substance is. And they have to provide you that information if you ask for it. Now, in the interest of fighting this fight together, I put together some documents for this presentation, and there's a link to them down in the chat, the first link, where I've put together the discovery request that I typically use in all of my cases, modified it a little bit for use by members of the public, along with all the documents that you would need in a case like this, to make sure that the person that tested the drugs is there if they did actually get tested, and also the documents you would need to file with the court to show that you followed the legal process correctly. So all of that is on there, and I'll be referring to that as I talk. So those documents have been posted on our website and are available. Everything is highlighted. So you go through, you fill in your information. I want to make the process as simple as possible for everybody to fight back against the state in these cases. So if you file a written request for discovery, and you'll see that in the materials on our website, you're asking for all the evidence that the state has. They have 15 days to respond. When you file that document with the court, you make a copy of it. There's a certificate of service that basically says, I swear that I sent this to this person on this date to make this request. And you file a copy of that with the court. And then the police officer that charged you has 15 days to respond. And he has to give you the evidence that you asked for. So it's really just a pretty short process of you fill in the form, you fill in their certificate showing that you sent it, you send the form to the officer or the deputy attorney general handling the case if it's a court of common pleas case. And then you file the certificate with the court. It's a very short process to ask for that information. And if the state or the police agency fails to respond, you can actually move for relief for failure to respond at the start of your trial. This forces the prosecution to go through the process in full, but it also provides you with valuable information, everything that the state's going to use in your case, and put you in a position to win your case later. The way you do that is, like I said, if you get that information back and you see that they haven't tested the substance and they don't have the ability to identify what the substance is, and they haven't even identified any experts, because you need an expert in Delaware to identify substances. And there's different ways that it can be done. It can be done through the chemical testing, as I described earlier. There's also some suggestion that it can be done by somebody who has other expertise in identification. I haven't seen that done yet. And then there is case law that they could bring in someone, the case law says like a drug dealer, someone who has personal experience with drugs, can identify drugs from their personal experience of dealing with the drug. I don't think they're going to do that for a civil violation. Go find somebody to take a look at your weed and testify whether it's weed or not. So the reason why you do all this, like I said, you're setting yourself up for later. If you see that they have no test, that's when you can prepare for the next step, and that's what we'll get to next. Pretrial motions. Before you start your hearing, after you've made this discovery request, you found out what the state has, you've gone through it, you've prepared for trial, you have the ability to make some pretrial motions before the court. And I want to jump to this. There's some stuff in between, but it's important because I just mentioned the state's discovery response and their obligation. The police's their obligation to respond to within 15 days. If the state doesn't respond to your request, it's Rule 16 is the JP court rule that's applicable to this. Prior to the start of the trial, you can tell the judge that you want to make a pretrial motion, explain to them that you filed a request for discovery and inspection per the court rules, and that there's a certificate of service that you filed that's on file with the court those are those documents that you sent to the police officer and the other document that you filed with the court, swearing that you sent that request in. If you explain to the court that you made that request, you have a copy of the request, there's a copy of the certificate of service in the court file, the state or the officer failed to comply, Rule 16 of the Justice of the Peace Court rules provides for remedies for failure to comply. The first thing I suggest is ask for dismissal of the charges. And the reason why is a critical element of proving a cannabis possession case is that the substance that was seized was in fact cannabis. And if the prosecution's failed to provide scientific testing that proves the identity of the substance seized, the case should be dismissed because that evidence is case dispositive, meaning without proving the substance cannabis, without having those tests, they can't prove the charge at all. So why move forward if they haven't even disclosed that they've done the things to actually prove the case? Now, if the court doesn't think that's an appropriate remedy, and some will, some judges will just say, if you didn't respond to discovery, I'm not letting you move forward. We're throwing the case out. They'll throw the case out right then and there. Other judges will tell you that they don't think a dismissal is the appropriate remedy. And, in the alternative, the court may ask about, are you agreeable to that evidence being excluded? Any evidence that wasn't turned over to you being excluded. So for example, if the cop shows up on the day of trial and he's got test results in his hand and a forensic chemist standing there with him, to testify that the substance was cannabis, but he didn't turn that over to you before, and you made your request, they didn't respond. 2 months later, they show up at court and they want to put on expert testimony, but haven't told you anything about it, haven't provided you any reports, haven't provided you any test results. Well, part of preparing your case is going to be, did they get test results? Did the test results come back positive? That's critical information that you want to look at. In theory, you would have the right to have your own expert look at the expert's testimony to rebut that expert. So when they show up on the day of trial and they have this new evidence that they haven't shown you before, even if they have the chemist there, even if they have the test results there, you can object to that testimony because you weren't provided that information in advance. And if you object and say, you're opposed to a trial by ambush of the state showing up with experts on the day of, when you asked for those experts 2 months ago, more likely that the judge is going to say that evidence is excluded. And there's case law to support that, excluding evidence when the state shows up. And one reason that you can provide to a judge is if they don't exclude that evidence, it just encourages the state in the future to not comply with discovery requests. The reason why we have that information is so we can have fair trials, so people can get information in advance and know what they're facing when they go to court. You have a right to that if you're accused. So if they don't comply and the court just lets them go ahead and put that evidence on anyway, there's no, disincentive in the future for them to comply. They'll keep, doing the trial by ambush and showing up. So if the judge asks, if they won't dismiss it, and they say, what about excluding this evidence? Yes, you want to exclude the evidence. Some judges and sometimes cops will say, well, what if we did a continuance of this case and have you come back on a later date, and then you can review this information and be prepared. That's when you really need to put your foot down and obviously be respectful of the court and the judge. But, if you took time out of your day to prepare and get ready for trial and come to court and put a suit on and go through the process, and the state shows up and they're not ready to go because they didn't follow the rules, your argument is they shouldn't get another, bite at the apple on that one. You're ready to go. The remedy in that case is exclude that evidence and walk into a trial that the state's not going to be able to prove their case because they didn't respond to you and they don't have the expert testimony that they need to prove the case. Now, as I said earlier, there's a good reason why you're not likely to receive a discovery response from cops. Often it's because they didn't have it tested. Sometimes, or most of the time, they just expect people to take a plea and be done. And then other times it's just because you have police officers who don't fully understand the law, who don't understand the procedure. Really, when you come to these things, if you're a lay person off the street and you're trying your case pro se, and it's the first time you've ever been in a courtroom, I can tell you, it seems in some instances the cops don't have a lot more experience than you do. So, should be a pretty fair matchup with a little bit of good advice and the information that's provided in there to go on and take these cops on and, show them something that they usually don't see from, people coming in off the street. So back to, if you don't receive a response, I touched on this before, if they show up with someone and they expect to testify, there's another circumstance. Sometimes what the cops do is they don't get the drugs tested. They don't have a chemist there to testify. And what they try to do is they try to make themselves the experts. And I've been involved in these cases. One of the cases that's cited the most in these cases was one of my cases where police officers came in, the state failed to get us a lab test in the time that it was due by the court. So the court said, like I explained earlier, you're not allowed to use that evidence. You're not allowed to use the medical examiner. You're not allowed to use the lab report. So what the state tried to do was put up every police officer involved in the case and have the officer say, I saw the substance, I smelled it, it smelled like weed, it looked like weed. We did a presumptive test on it, a regent test back at the troop, and it tested positive, and we sent it for confirmation. And well, they didn't get it back, so they can't testify about the other part, but they just basically say it smells like weed and it looks like weed. And in cases in the past, in my case, Norman versus State, I objected to that, and we took the case to the Supreme Court, and the Supreme Court said, when the state fails to get that chemist test and provide it to the defense in a timely manner, they can't then have police officers get up and talk about, I have this experience in drug recognition, I've been to these schools, I have all this training, and then testify in the place of those experts. I think the reason for that is simply because it discourages the state from going through the full process and doing what it's supposed to do. So if a police officer shows up on the day of trial and he's not provided you with any testing and doesn't have anybody there to identify the substance, know that sometimes they'll try to get up there and be the expert themselves. And the court has said, you can't do that. In the case of Theodore Norman versus State, Delaware Supreme Court, 2009, also Wright versus State, Delaware Supreme Court, 2008. And I'll post an update on Facebook with some of this information if you want to use it in a future case. And so people who watch this have those cases. So when that officer shows up and tries to testify as an expert, you can say, Your Honor, I object to this testimony, and you don't have to use the technical term, but I'll tell you what it is. Technically, it's called a motion in limine. But what you can say is, you object to the testimony and you requested it be excluded from the trial. And the reason why is that, first off, the police officer has not identified themselves as an expert because they didn't respond to your discovery request. To testify as an expert, you have to disclose experts. You'll see in those materials, if you go to our site, that one of the things that you ask for in the discovery request is for the prosecutor or the cop to identify any experts that they're going to use, the information that they relied on to make their opinions, and a report of their findings. So if the officer shows up on the day of trial and tries to say, I'm an expert, I've done all this training, you can tell the judge that you object and you want to exclude the testimony because, one, the officer didn't previously identify themselves as an expert. They didn't provide you with a report. They didn't provide you with any information that they based their opinions on. So under the rules, their testimony should be excluded, just like the other stuff that they didn't provide you. Whether the medical examiner shows up or not, if they didn't provide you this information in advance, you ask the judge to exclude it. And then the second request that you make is that not only does the judge exclude the officer from testifying as an expert in your case, they exclude any testimony from the officer about what the substance was. And the reason why is Norman versus State and Wright versus State, that police officers can't testify as lay witnesses and identify a substance. There's case law, and you can point to the case law to the judge I've done it before. A lot of times what they'll do is they'll say, okay, we're going to go forward with the trial, and they'll have the trial, and then they'll go back and they'll do their research. And then 2 weeks later, you'll get a little written thing from them that says they did some research, and yeah, you were right about Norman versus State and Wright versus State, and all the testimony by the officer is excluded, and therefore there's no evidence. So those are 2 pretrial motions, and the goal in those cases or in those motions is to prevent the arresting officer from identifying the substance. If they can't identify the substance, they can't prove their case. Now, there might be other opportunities in your case, and things that you can do pre-trial. That's going to be case specific. If you have a fishy stop, like if for some reason you get pulled over and you ask the officer why you're being pulled over and they don't have a reason, or they say, I'm pulling you over, because you look suspicious, or just some bullshit reason, the Fourth Amendment still applies in all these cases. So there are some circumstances where police officers pull people over or search people's houses or stop them on the street and search people when they really had no reason to stop that person in advance. And there's other opportunities for pretrial motions and things that you can do to fight your case. And those would be something that's really case to case. This other advice is really more general for a general case. So if you have a suspicious stop, what I would say is give me a call or call another attorney, take a few minutes to talk about it, and get some advice if there's case specific stuff. So next, I'm going to jump on to trial, and in trial tie in your preparation that you're going to engage in for trial. I mean, obviously what we've talked about before, part of your preparation for trial is going to be reviewing what the state gives you, if they give you anything. 2, reviewing your notes and the information we put out, on this seminar, just to be prepared in terms of things that could come up in trial, in terms of your objections and trying to keep that different evidence out. But also you want to prepare, even if the state has everything, even if they got everything tested, even if you're going to go in there and lose. I mean, my position is, why not put them through the process and still make them respond to discovery, go to trial, taking out of their time? If you're going to pay $131 anyway, I think we should just go in there and prove the point that if we're going to go down, we're going to go down fighting. So in preparing for trial, put on the full show. At trial, you're going to have an opportunity to give an opening statement, and you don't miss out on an opportunity to, waste some time in state funds making your opening statement. Most of these trials, realistically, you're going to have 1 or 2 police officers. Those officers are going to testify, and they're going to make the allegations that you already know that they're going to make it. Most of what they testify to, they read their report before they come in, and they essentially give a recitation of their report. You're going to have an opportunity to question them back. And this is an opportunity where, really, it could be a fun exercise if you're in a no-lose situation in these civil violation cases. You're not going to walk away with a mark on your record, and you don't have much on the line. So, as you prepare, what I would say is, if you're stopped and you're given a civil violation where you're in a car with 4 people, it could be anybody's stuff. I mean, if you're in your pocket, it's going to be harder to argue. But if you have 4 people in a car and cannabis in the glove box, you've got a factual argument that you want to prepare to be able to ask the cop and point out and illustrate the factual issues in the case. If you have a car where, cannabis is found in a purse versus the trunk versus a men's jacket, these factual circumstances are things that you want to point out to an officer in your cross-examination of them to illustrate to a judge. Could have been somebody else, wasn't your cannabis. I mean, one of the ways to win these cases is show that, or prevent the state from showing that it was cannabis. And that's what we talked about with, objections to testing and objections to different witnesses or lack of testing, really. But, your other way to beat a case is prove it wasn't you. They got to prove the substance, but they also got to prove it's you. So if there's any factual circumstances that would suggest that it's not yours or that it could be somebody else's. You know, if you have two people in a car and cannabis in the center console, it's 50-50, or at least that's the argument. Or really the argument is it could have been the other person's. You don't know what the percentage chance of that are. So you can beat the preponderance of the evidence standard. So, things that I would advise on going into the trial that you want to prepare for. There's going to be things that police officers try to do that you can frustrate them and do things to make their job more difficult in trial. Obviously we talked about if they attempt to identify the substance, you can object to their lay opinion or the foundation for their argument. Sometimes police officers will try to say they have these little roadside tests with a liquid and they put substances in it in the liquid and it turns a certain color when it's positive for a substance. It's called reagent testing. And cops tried to testify about what the results were of the reagent testing that they did. Those tests are not really accepted in courts as evidence. So if a cop gets up on the stand and he says, I took out my reagent test, you can object and say that's not a scientifically reliable test and object to it coming into evidence. Sometimes police officers will try to testify to, someone else said something. If that person is not there to testify at trial, that's hearsay. You can't testify to what someone else said. So if you get a cop up there who says, if you had other people in your car when you got pulled over and those people aren't there to testify and the cop gets up and tries to say, well, this other person in the car said, objection, hearsay, that other person's not here. If they want to put on evidence of what that other person in the car said, they need to bring that other person in. If they try to mention criminal history, if you have a bunch of past cannabis offenses on your record and they try to mention that, you can object to that. Evidence of any prior bad acts or crimes that you engaged in is generally not admissible. So be ready for that. Cops will try to slip that stuff in sometimes. And then sometimes cops will try to say, I sent this stuff for a test and it was positive. Again, that's something that's hearsay and you can make that objection to try to keep that evidence out. So in terms of your preparation for trial, you're looking at two things. Can they prove it was cannabis? Can they prove it was your cannabis? And every case, like I said, is going to be different. So you're going to have to be creative and look at circumstances. If you're charged with two people, if you're in someone else's home, if you're driving someone else's car, there's all kinds of factual circumstances where you can think of, how it could be somebody else's, how it could not be your cannabis, because what they have to prove in these cases to prove that you possess something, they have to prove that you knew it was there, and they have to prove that you had the intent to exercise dominion or control over the cannabis. So what that means in terms of legally, okay. So, what that means legally is they would have to show that if you're driving a car and there's a bag of cannabis in the center console, they have to prove that you knew it was there, but then they also have to prove that you wanted to exercise control over that object. So let's say you've borrowed someone else's car and you go to the store and you get out from the store and you open the center console and you look in and there's a jar of weed in your buddy's center console. So you close it back up, you're driving back home, you get pulled over and the officer searches the car and he finds the jar of weed in the center console of your buddy's car that you borrowed. Now you knew it was there, but that's not all they need to prove possession. They need to prove that you had the intent to exercise control over it. So that would mean that you wanted to take it, smoke it, do something with it, move it from one place to another. But if you just borrowed your buddy's car, or if your argument is that you just borrowed your buddy's car and saw that in there and didn't have that intent, at trial, the way you can try to prove that with questions from the officer is you ask them, did you fingerprint the jar? Did you DNA test the jar? They didn't. There's no way to spend that money on that. But you ask them those questions. And you could do that in any case. Any case. You ask them if they found it in a jar, if they found it in a bag, did you fingerprint test the jar? Did you DNA test the jar? How do you prove who possessed something or that you knew where it was? Or, obviously there's circumstances where if you get caught with a bag of weed in your pocket, that becomes a little bit harder argument. But if it's in a car, if it's in a house, there's things that they need to prove other than just you were around it. You know, that's not enough for possession. You got to know where it is, and you got to have that intent to do something with it. So when you prepare for these trials, you know, be creative in thinking about ways, how can you question this officer and ask them questions about things that they failed to do to prove that that cannabis was yours. Most of it's going to be, did you test the bag that it was in or jar that it was in to see if there were fingerprints on it? You know, the type of container it was in. You know, I know it's a little sexist. Well, it's a lot sexist if to say, like, you know, if it's found in a purse, it's not the guy's. But I mean, there's people, all kinds of people that carry purses. So, you know, sometimes that stuff works with judges where, like, if the type of container that it's found in, you know, I had a case where, you know, it's found in cannabis found in a pink pencil box, and my guy was like 6'4" and 250. And sometimes the, you know, sexist stuff works the other way, I guess, where, you know, prosecutors don't believe allegations because of the state that the cannabis was found in. So, you know, sometimes those things work with judges, just because typically, you know, purses are carried by women, and, you know, some of the gender stereotypes, the judges will consider that kind of stuff in terms of evidence. Now, at the end of your trial, you're going to have an opportunity to make a closing argument. This is another thing that you want to focus on when you're preparing, you know, and the arguments are going to be quite simple. You know, I've hit on them. There's only a handful in these cases, and so much relies on, does the state follow the process correctly? Do these officers follow the process correctly? You know, without proper expert testimony, the court can't conclude by preponderance of the evidence that the substance seized was in fact cannabis. Someone else possessed the weed. There's not enough proof that you possessed the weed. You don't have to prove someone else possessed it. The state has to prove you possessed it. No proof that the cannabis was a prohibited form of cannabis. That's a new one that I haven't had an opportunity to test out yet, but I'm hoping to test it soon. Hemp is now legal in Delaware. Both hemp and you know, adult use cannabis contain THC. When they do the THC testing on these things, a lot of times they're not testing levels. So hemp will come back as positive for THC. I had a case where some guys stole a bunch of hemp and it came back positive for THC. But when they actually looked at the substance and looked further into it, they realized it was hemp flower. It was just testing positive at low levels because their tests don't pick up levels. So, I mean, I think there's an argument to be made in these cases where a civil violation is alleged, even if the state or the prosecutor or the arresting officer come in and show that, yes, it was in fact cannabis, and they prove, you know, that the substance was cannabis through a chemical test. I think there's an argument still to be made where you say, you know, there's been testimony that it was in my pocket in a bag and then it tested positive for THC, but there's a lack of evidence and proof beyond the preponderance of the evidence because there was no testimony by the state about the THC level of the product seized. Because hemp flower with less than 0.3% THC content is legal, but things above that are considered recreational cannabis, which is not legal yet. So I think there's a question and argument to be made, especially in these low-level cases where there's not a lot to lose other than $131 fine. If a judge will accept, you know, that the simple testing that THC is in the substance proves that it's cannabis, because in theory, it could be either hemp or it could not be. So if the requirement is proof beyond a preponderance, my argument would be, you know, anything where it can be, it can't be, it's 50-50. 50-50 is not enough for them. They need more than 50. So, you know, the argument is it's not proof beyond a preponderance when it could be hemp, it could be not hemp. Make them testify or make them put on some evidence that it's above the THC threshold for hemp. I haven't got to test that one, but, you know, hopefully somebody will. Well, hopefully they'll stop charging people and nobody will have to. But, you know, we want everybody to challenge these, and I want everybody to challenge these. As I said, you know, these civil violations are a no loss proposition for you if you're charged with just a civil violation. I've tried them before. I've done them pro bono. I've done them for a $131 fee because some people want to pay me rather than pay the state just to fuck with the state. I mean, I wish I could do more of them, but I don't have enough time to do the thousands of civil violation cases that come up. But if everybody joins together and we all as consumers say, you know, if I get stopped for a traffic violation and they find some weed in my car and they charge me with a civil violation and you pay the speeding ticket and that case is done, and then the state wants another $131 from you for having a little bit of weed in your car, you know, why not have a trial? So, you know, really this is a call to action of you've got nothing to lose when the worst that you can do is the same outcome as just giving in from the start. Takes you a couple hours of your time. The resources we've provided should be as simple as filling in some highlighted fields. And I can tell you, if you need advice on this, you know, while I can't do every case, if you have a civil violation case only, and you need to talk for a few minutes on the phone, and you have some questions about, hey, I've got this, you know, civil case coming up, looking for some pointers, give me a call. I'll put my info down in the chat section before we end today. Give me a call, shoot me an email, we'll talk. You know, I just want to provide people with the resources to do this. And many of these same tactics, you know, just to comment on other possession cases, if it's something other than a civil violation, if it's a misdemeanor cannabis possession case, and then let's say you have some edibles and they charge you with a misdemeanor, and you go to court of common pleas, which is where that case would be prosecuted, there's going to be a prosecutor there. And if you go in and the prosecutor says, here's a plea offer, and the plea offer is misdemeanor cannabis possession, and you're charged with misdemeanor cannabis possession, you know, that's a kind of a no-lose situation as well. You know, you might benefit from having an attorney talk to that person, talk to that prosecutor, and say, can we be realistic here, and, you know, not, you know, burden this person for the rest of their life with a misdemeanor conviction on your record. They might be able to get a better offer. But, you know, if you're in a situation where you have a misdemeanor case and a misdemeanor offer, that's another one where you really don't have much to lose. So these situations where, you know, you're in no loss propositions, my suggestion would be, and the reason why we put this on, you know, fight it, make it expensive for the state, you know, be a burden on them as they are a burden on us. Obviously, like I said, if it's other things, if it's bigger things, if it's felonies, you know, those are things that are going to have to be addressed case by case. But, you know, these civil violations, these possession cases, you know, this is really a call to action to fight these things vigorously, to file discovery requests, to make pretrial applications, to show up and do these trials. You know, I can tell you, the first time I got charged with a traffic ticket when I was 16 years old, you know, I went to JP court and they said, you can plead to it and pay the fine. And I was like, what if I go to trial? And they were like, well, you get the same fine. You know, at 16, I was like, fuck it. Like, I'd rather, you know, test my luck than pay the fine, and went to trial and lost. And then the next one I went and won. So then after that, I mean, when you're in a situation, and I've been in this situation, I've had clients who've been in a situation where the state is just trying to impose something on you and you have nothing much to lose by fighting, why not fight? And I think a lot of people, it's, you know, they want to save a few hours of their time, you know, not going to court. But this is a different fight. You know, this is something where if you're a consumer, you know, take some time and call it advocacy, call it fighting on behalf of legalization, to spend a few hours of your time to go to trial, to make the state earn it. You know, even if you lose, you know, we talked about the title is, you know, how to win your cannabis possession case. And I would say, you know, if you get charged with a civil violation and you put them through the process and they have to respond to your discovery request and they have to come to court, and you spend an hour and a half in trial, and you spend, you know, hours and hours of the state's time. And that includes, you know, having a cop come there and having a judge and having the medical examiner show up and maybe a second cop, and you put them through the process and you waste all that state time And then we as advocates could go back and say, look at how much time and money you're spending on this bullshit. That's still a win. Even if you get found responsible and you have to pay that $131, if you spend, a couple dozen man hours of state time, to prosecute a petty cannabis violation, that's a win. So I think we're in a situation where with these petty cases, even if you lose, you win often. Obviously, like I said, there's cases that are a little bit different. So if you ever have any questions, I'll pop my information down there now. You can give me a call or shoot me an email. I just want to thank everybody for tuning in tonight. And I think we have some questions.
Yeah.
Okay.
Hey, Adam, I got a question when you have a minute.
Sure thing. Who am I talking to?
Mark Jacobs.
Okay, Mark, what's up?
You implied that if you win the case, you don't have to pay court costs. Is that true?
Yes.
I thought it was. I thought you had to pay court costs regardless of win or
No,
lose.
if you win your civil violation, you pay the court nothing.
Oh,
Because
cool.
they don't want to. It would be problematic constitutionally to discourage people from exercising their rights.
Yeah.
To it'd basically be like a trial fee.
Mm-hmm.
So no, if you win, you don't pay court costs. And I can tell you, I've tried these cases. The cops are usually surprised when someone shows up. They're particularly surprised when an attorney shows up. But I'm sure they'd be equally surprised when someone prepared shows up just to fight them, just to fight.
There's another question in the chat here. So 10 days after arraignment, do you have to file discovery?
That's correct. So what the rules say, the Justice of Peace Court has rules that govern civil violations, and in those rules, it references all discovery is falls under Criminal Rule 16, Justice of Peace Court Criminal Rule 16, and Criminal Rule 16 dictates the timelines and what you can discover. So if you look up Justice of the Peace Court Rule 16 in Delaware, you'll see the list of the items that are discoverable, how long you have to file that request, what you have to do when you file the request, and how long the state has to respond. And in the materials for the course, you'll see on there the discovery request that I've posted on there. And then there's also a certificate of service. You send a discovery request to the officer, you file a certificate of service, basically swearing that you sent it to the officer, and you take that and you drop it off to the court and you file that with the court. So discovery is a simple process of one thing in the mail to the officer or the deputy attorney general, one thing to the court, just a copy to show what you sent them. And you'll see that in the materials. Anybody else?
I got one more question. There's no one else.
Sure.
Would you reiterate what you do if you have filed for information, you've gotten what they've sent you, and the cop tries to introduce something new at the trial?
Okay, so if you've asked for evidence, and you'll see in Rule 16 the stuff that you're entitled to, like I said, the biggest one is results of scientific tests, statements, documents, and things they intend to use against you. The biggest one is the test. So, let's say that you're talking about a situation where they don't respond properly or they don't respond at all.
No, that they responded, they sent you information, but then they tried to introduce evidence that was not revealed to you in your discovery.
Okay, so the argument in that case is, as a sanction for their discovery violation, I guess the technical term of it would be a discovery violation, that they're trying to introduce evidence that they didn't provide you in advance when you asked for it. So you would be asking for a sanction for their discovery violation, and the sanction that you would ask for is to exclude that evidence.
Okay, cool, thanks.
So anything that wasn't provided in advance, you asked to exclude it because of their obligation to provide it, and they didn't provide it. So I guess technically the argument is that your due process rights are violated by not having that information in advance.
Okay, cool.
Anybody else before we sign off?
So I just wanted to real quick, if there's no other questions, maybe we could just.
Can I ask one real quick?
Sure.
Yeah, go for it.
People like us are really afraid of courtrooms and things like that. And it sounds like you're saying that if you win or even if you lose, you're just losing $130. And someone like me, I fear that they can add a charge, or can they change the charge when you're in court?
No. So one of the requirements when you go to court, also in those rules that I was talking about, in the Justice Peace Court rules, you know, and constitutionally, you have to be advised of the charges before you come to court. It would be absolute due process violation to show up to court and have them say, okay, we're changing the charges. When you're charged, you're arraigned, you're advised of the charges against you. So if your charge is a civil violation for possession of cannabis, and you show up to court that day and you say, I want a trial, they can't say, oh, well, if you want a trial, then we're adding these charges. They're prohibited by the rules and they're prohibited by the Constitution from doing that. So if they try to do that, and any judge is going to understand that, you have to have notice of what you're defending when you go to
Thank
court.
you.
So if you go to court and they try to do that, no judge is going to let a prosecutor or a cop add a charge on the day of trial that you're not prepared to defend. That absolutely violates due process rights.
Thank you.
We'll take more questions, but I also want to see, we have these documents and I put the link over here in the chat. But I was actually going to screen share and see if Adam would just briefly explain some of the documents that we have up on our website to assist people.
Okay. Yeah.
Let's see. All right. Is it this one?
No. Yep. Okay, so what do you guys see on the screen right now?
Your computer screen.
Oh,
Let's see. Give us 1 second. Is it that one?
that one.
There you go.
You see a Microsoft Word document?
Yes.
Okay. And at the top it says fight back, how to win your cannabis possession case.
Yep, in green.
Okay. So Zoe just wants me to run through these documents that I touched on earlier. So the first one is the request for discovery and inspection that I talked about. This is how you get the information from the state. And I've highlighted all the fields that need to be filled in here. So what you'll see is your name, address, return address, just like a letter. The next section here, you have these highlighted sections that have the name of the officer, the police agency, and then there's different addresses for the Department of Justice. If your case is in the Justice of the Peace Court, you're just going to send it to the officer that arrested you. If for some reason you've been charged with a misdemeanor and you're fighting the case on your own, you have to send it to the Deputy Attorney General in that county that you were charged. So I have the addresses here for Kent, Wilmington, and Georgetown if you're representing yourself on a misdemeanor case in the Court of Common Pleas. So JP Court, just the officer. Court of Common Pleas, misdemeanor cases, one of these 3 addresses. You fill in the case name, your name, last name, case number, and then depending on who you're sending it to, address the salutation to the deputy or officer. And what you'll see in the next section, review this. This is what I use in every case. Asking the state for all the information they have, written statements, tests, documents, photographs, maps, diagrams, everything that they're going to use, information that is subject to the expert witnesses rule. Everything is in there. This is a pretty standard request for discovery that's going to get you all the evidence that the state has against you. And then at the bottom, just change out the section that says your name and type your name on there, sign that. And when you've done that, if it's a JP court case, you'll send this to the officer. And then the next document down here below, this is what I was talking about earlier. You send the first document to the officer. This second document is your notice of service, where you're certifying that you sent a copy of your request for discovery and inspection in the mail to the officer on that date. You sign it, you fill in the signature block there. So what that does is that puts you in compliance with the rules for discovery. You sent the request to the officer, you sent the court proof that you sent it to the officer, and you've complied with the rules for your case. And all you'll need to do in here is just fill out the information. What court is it in? That's going to be on your paperwork, the case number, your name, who you sent it to. The document I skipped over, this is part of my discovery request, and I think it's important to send this letter. When you send it to the officer, both letters go to the same officer, so you can send them together at the same time. I just sign them as two separate things. Same thing, officer or deputy attorney general, depending on which court it's in, case name and case number. And what this letter is, very short. So, I mean, it just says, this letter is the defendant's demand pursuant to 10 Delaware Code 4332 for all persons involved in the chain of custody of any evidence presented in court. Please subpoena the medical examiner personnel who prepared the ME report. This is setting the state up. You know, we talked a lot about, you know, making demands of having someone there to testify about who tested the substance and what the substance is. There's a section of Delaware law that says if you're a defendant in a criminal case or one of these civil violation cases, you can make a demand on the state to have everyone in the chain of custody there to testify at your trial. And by sending this letter, you know, what you're essentially demanding on them is the cop that arrested you or charged you with a civil violation, if he gives it to another officer and that officer drives it to the medical examiner's office and they test it there, and another officer picks it up and brings it back to the troop, and then that officer hands it off to another officer who brings it to court, they have to bring everybody who touched it in the chain of custody to court. So it's another way of being a burden on the state and requiring them to bring in not just the officer that arrested you and the medical examiner, but everybody who touched that substance in between in the testing process, to make them bring those people to court. So I filed this in all of my cases, drug cases, with the discovery request to make that extra demand and to make that record. So when you go to court, you know, make copies of all this stuff. It's in the instructions that I put on the documents to make copies of stuff. So when you go to court, you can say to the judge, I filed this discovery request and here's what I asked for. And I filed this chain of custody demand, here's what I asked for. And the state didn't do these things. So those are the documents that I've provided. I have a notice of service for the Court of Common Pleas if your case is a misdemeanor and you're fighting a misdemeanor case. But most of these cases are going to be justice of the peace court. And these are 3 documents, you know, that you can use to demand the evidence against you and make the state prove it. So I think that covers everything, unless anybody else has any questions. You know, I want to thank everybody for coming out. Zoe, you have anything else to sign off?
Yeah, I was gonna.
So I'm going to turn it off to turn it over to Zoe to sign off. But I want to thank everyone for coming out tonight.
Hey, Adam, thanks a lot.
Thank you guys so much for joining us tonight. We appreciate you guys taking the time. And thank you so much to Attorney Adam Windett for putting together all this program and the materials. We have this program recorded and it'll be available on our Facebook, and the materials have already been published on our website. And I put the link already down in the chat. It's delawarecannabis.org/resources. And I just want to mention a few things before we sign off in terms of knowing your rights. So obviously, Adam talked about what happens after you're charged, after you have a civil citation, but there's protections that you can take as a citizen and invoke your constitutional protections to hopefully thwart an arrest and not, be cited or arrested for a possession offense. And those are your 4th, 5th, and 6th constitutional amendment protections. So your 4th is you do not consent to a search, that they have to have a warrant or, you have to give your consent in order for them to search you. Cannabis gives them a probable cause search. So based on the very odor of cannabis, they can search your vehicle, search your person, search your home without your consent and without a warrant. But you can still say that you don't consent to that search. That does not mean preventing them from searching or doing anything to thwart them from arresting you or something like that. It's just a verbal evocation of your constitutional protections. And you say, that you do not consent to this search and you're invoking your 4th Amendment constitutional right. And Adam spent a lot of time talking about what happens after you go to trial and things like that. And if you are charged or do have a civil citation, the best defense for your trial is not giving them a statement. And once again, that's your 5th Amendment constitutional protection. And you can just simply say, I do not wish to give any statements or talk to you without an attorney. And you can invoke your 5th Amendment constitutional right. And then your 6th Amendment is your right to counsel. So if you are being charged, this wouldn't necessarily apply for a civil citation, but for a cannabis arrest, if you are arrested for cannabis, whether it's possession or a felony or something to that degree, invoke your 6th Amendment constitutional right that you have the right to counsel, and that you don't want to be questioned without counsel. And once again, that's your 6th Amendment constitutional right to counsel. So, like I said, I just want to thank everyone who joined us tonight. If you've been charged with a cannabis offense or issued a civil citation, we hope that you found this information helpful. We also have information on the expungement and pardon process on the same page as our resources that are on tonight. So we actually have a joint project with Delaware Normal called the Cannabis Expungement Project, where we raise funds to cover the cost for those who are eligible for expungement of their charges. And you can go to erasetherecord.org for more information on that, or you can contact us directly at info@delawarecannabis.org. We're also looking for individuals that have been arrested or issued a civil citation to share their stories. And it's part of our outreach campaign and awareness campaign that we're doing in support of cannabis legalization. We want to show legislators the people that are being affected by these laws. Like I said, there's, over 6,000 a year, over 13 times a day, over 100 times a week, over 400 times a month. An individual is charged or issued a civil citation for a possession only case. And we're looking for individuals that will share these stories publicly. And I'm going to drop the link now. You can go to bit.ly/shareyourstory.cannabis or /cannabis. And I'm putting that in the link right now. So if you have a story and would like to share that with us, please go to that link and fill out that form. It's also really important that we pass the adult use legalization bill this year and end these possession only offenses once and for all. As I mentioned, the first phase of cannabis legalization will be introduced in the House soon, and we need a lot of support to pass that measure. So please contact your elected officials and ask them to prioritize cannabis legalization in 2021. We're actually hosting a virtual Delaware Citizens Cannabis Lobby Week from January 19th to the 22nd, where we're asking people to make an appointment with your local representative and senator for that week and ask them to support the upcoming cannabis legalization bill so we can end the arrests, end the police contact, end the prosecutions, and the convictions for cannabis possession. You can find more information about that on our Facebook or by subscribing to our emails. And we'll also be going over information on how to citizen lobby at our monthly public meeting, which are always the second Tuesday of every month. So it'll be next Tuesday from 7:30 to 8:30 via Zoom or call in, and you can find out more information on our Facebook. Contact us to volunteer or for more information. And once again, I want to thank everyone who joined us tonight. And we hope to see you again soon at one of our upcoming events. And thank you so much. Everyone, please stay safe. Good night.
Thank you,
Thanks
Zoe.
for joining us.
Good night, Zoe.
Good night.